In this video, we're going to give you some more tips for oral argument. I asked each of the Moot Court Board members in this video to think about what their top 3 tips are for oral argument. And so they're going to give you some of those tips now. We're going to start with Megan. What are your top tips for oral argument?
Yeah, I'll go ahead and give 2. My first one is to have a great roadmap and memorize it. So I'm sure you guys have already learned what a roadmap is, but if you could have a great roadmap and catch the judge's attention right away and tell them exactly what you're going to argue and have it memorized, because that's where they likely will have the most eye contact with you. I think that's my first tip. And my second tip would be practice makes perfect. And so they'll tell you to practice in front of the mirror. And it sounds kind of silly, or at least I thought so at first. But the more that you do it, the better that it will become. And so I would just suggest to go ahead and try to say your argument in front of the mirror.
Story.
I have 3. My first one is that judges' questions aren't always trying to be argumentative towards your viewpoint. And I know that I struggled with that, and I was always argumentative back and trying to prove them wrong. But sometimes they really are trying to help you because they like your side of the argument. My second is to know your case law very well. Definitely do the research and know your cases. And then my third is just to remain calm and take a deep breath before you walk up to the podium.
Great. Sarah?
So to pick up off of Dory's, one of mine is just breathing as well. And something that I always try to do is to place breaths strategically throughout my argument. So whenever I want to make a really important point, I try to make sure I pause whenever I do and take a breath there, because not only can that help you just stay calm and speak better throughout your argument, it also kind of gives more power to that point that you're trying to get to as well. Another tip that I have is to know both sides of your argument. So one thing that I'm really bad about, and my competition partner can speak to this, is that I really can pick the holes in any argument. So I can pick the holes in my argument, I can pick the holes in the opposing counsel argument, but I also see that as a strength because I know how to figure out ways around that, and I know how to set up my argument to try to avoid those rabbit holes. So if I know that there's something that could get me in trouble or could get me into a corner, I try to avoid it, but I also try to have something in my back pocket to answer if I get asked about that. So you have to know the weaknesses of all of your arguments and know both sides of the argument to really do well. And then I just have to practice with a friend, practice in front of your husband or boyfriend or whoever. Just really try to practice outside of just your practices for class.
Okay. And Logan, why don't you finish this part up?
I have 2 for you today, and the first one is know your record. Judges love record sites, and every time you can pull one up, or if they mention something and you can say, well, on the record at page 3, whichever page it is, it's just another point in your book that they think, wow, this person knows what they're talking about. They know the case. That's what I'm talking about. The second one is confidence is key. Even if you don't really know what you're saying is the right thing, but you say it confidently, they're probably going to just go with it. I mean, if you say it and then you're like, that's the way it is, they'll go, wow, that must be the way it is. Like, no one's going to question you on it or call you out except for that one judge in 100. So if you say it with confidence, you'll probably be all right.
Yeah, we say fake it till you make it, right? They probably don't know that you're not correct, but if you sounded correct, it's going to be persuasive. I'll just add one more thing related to what Dory said about knowing your cases. What does that actually mean? Don't be the person who cites a case and the judge says, what are the facts of that case? And you go, I'm sorry, Your Honor, I just don't remember at this moment in time, because that just basically blew that case completely out of the water in terms of its usefulness for you. So when go back and look at your cases that you're planning to cite, make sure you know what court decided it, make sure you know what the facts are. You don't have to volunteer those things if it doesn't make sense to your argument, but you should know them so that when the judge thinks they're going to get you by asking that question, you're going to go, aha, nope, I know better, and I can give you the facts, and I can give you the court, and I can give you the date, those little details about every case that I'm going to talk about. So there you go. I hope those are some useful tips, and that in the end, the most important thing about doing an oral argument is just have fun. I mean, it's what lawyers do. They talk about the law, so have fun with it. And we wish you all good luck. Oh, I'm sorry. I was going to end the video, but you know what? We were going to do one last thing before we quit, and that is, I asked the group if they would just do sort of their 15-second final words, your pitch for why it is you would have somebody take AAA or try out for Moot Court. And so, Dory, I'm going to throw it to you.
So I said every attorney or anyone in this field that I've ever heard of has to either speak in court or be able to write professionally. And Moot Court is just kind of there, and so is AAA, and it helps you have that GUFF, I call it GUFF, it's grace under pressure, to stand up in front of the judges and be able to answer their questions. So when they do answer those harder questions, you're able to be composed and kind of come up with something. So I would suggest that if you are on the fence to take AAA, there's really no disadvantage to taking the class. You'll become a better writer, a better speaker, and overall a better law student.
Sarah, I think, is where we're going to go next.
Yeah, I would kind of agree with what Dory said. Don't be so afraid of it. Don't be so intimidated. Be willing to push yourself outside of your comfort zone. If this is something that you're just naturally good at, great. We always need those strong advocates. But also, you know, if it's someone like me who never really enjoyed public speaking, don't be afraid to push yourself outside of your comfort zone, because like Dory said, you will have to speak in court, you will have to do things, and it's better now to, you know, push yourself out and get better at those things than to be really embarrassed and really nervous when you actually are a lawyer and you have to go into court and you are not comfortable at all. So it's better now just to push yourself, and it really, really does help improve your writing and your oral advocacy skills.
So Megan, I think we were going to go to you.
Yeah, I just wanted to encourage everyone to take AAA and try out for Moot Court. I think that it gives us a leg up in the job market after graduating. I recently had a classmate of mine text me and ask if we've ever had to write an appellate brief. Well, as you know, 1 a year you do, but that's it. And so the classmate had already forgotten. But if you take AAA and if you get on Moot Court, that's 5 appellate briefs under your belt. That gives you that leg up whenever you are interviewing, and you can tell employers, hey, I've written appellate briefs, I've worked on my oral argument skills, and this is what I can contribute if you hire me. And so I hope that all of you will take advantage of this opportunity.
Okay, Logan, do you want to be the concluding voice here?
Yes, I will. I think AAA and Moot Court especially, it's as close as you can get to the practice of law without someone's future or finances being on the line. So, I mean, you get all the writing that you can imagine, and you do the oral advocacy, and it's all very professional. I mean, it quite mirrors how it is in the real world. But at the end of the day, it's a competition. It's fun, it's a good time, but no one's going to go to jail over you not winning your argument, and no one's going to lose money or lose their house. So it's really it's a very good way to dip your toes into the water of litigation and brief writing for appellate advocacy.
Yeah, I think you just came up with our new slogan, do Moot Court, you won't lose your house. But that's good. That's great. So thank you guys so much. I think all of that is good, useful information. And for those of you who are first-year students who are watching right now, we encourage you to, you know, if you're even thinking about doing Moot Court, make sure that you sign up for advanced appellate advocacy, because that is a requirement in order to get on the Moot Court board. And if you have any questions about anything, feel free to reach out to any of the folks you see in this video or any of the folks you've seen in any of the other videos, because one of the things that I'm very proud about this group of folks, these people that I've been working with on Moot Court, is that they are very gracious and very generous with their time. And so as long as you don't bother them in the middle of the night when they're trying to get a good sleep, I suppose Other than that, they will be, I think, very willing to talk with you and help you in prepare for that or the oral arguments that you're going to be doing, and to give you more information about moot court and AAA.